Welcome to 1 Minute Matters. I'm Paul Stewart, partner in Dykema's Environmental Group. When the Supreme Court overturned Chevron last year in its Loper-Bright decision, it ended agency deference for interpretation of ambiguous statutes in most, but not all cases. Today, we are breaking down a particular instance where agency deference can still apply post-Loper-Bright. The Loper-Bright ruling made clear that ambiguity in a statute is not a basis for a court deferring to an agency's interpretation of a statute. But the delegation must be explicit. In other words, ambiguity in a statute is no longer considered an implicit delegation of interpretive authority to an agency, as it was under Chevron. The Sixth Circuit recently addressed the delegation question in Montezuma-Reyes v. Garland, where the court considered whether agency deference should be afforded to an interpretation by the Board of Immigration Appeals of the statutory phrase, exceptional and extremely unusual hardship. But the court found an absence of statutory language expressly vesting the agency with discretion to interpret those terms, meaning agency deference did not apply. Expect more attention than ever on the question of whether Congress delegated interpretive authority to an agency, and expect the possibility of inconsistent decisions, given there could be considerable disagreement over whether or not the statutory language at issue in a case evidences delegation. The post-Loper-Bright legal landscape is still taking shape, and the delegation issue addressed by the Sixth Circuit in Montezuma-Reyes is just one of the many we are watching. Need guidance on environmental enforcement and regulatory compliance in this evolving landscape? Click the link below to contact Dykema's environmental team today.